Good morning and welcome to this morning's webinar from CIF in conjunction with our corporate partners Decipher. Webinars entitled Construction Contracts, Disputes and Dispute Avoidance. Construction Contracts Act is one of the single most important pieces of legislation that the CIF sought from the time of the recession, when there was a very significant impact on cash flow right through to its enactment in 2016. We didn't get the perfect act, and as a result, made a significant submission to the department in early 2017 to seek improvements. The department have always engaged very constructively with CIF and the industry on the implementation of the act, and most importantly, they have listened. If the act is shown to impede the original policy intention of improving cash flow throughout the supply chain, then the department will no doubt consider a review in that context. This morning's session is to help you to understand how the Act is operating and give you some ground zero level intelligence on how to not just react in the event of a dispute, but also how to set yourself up and be best placed to completely avoid disputes in the first place. So we have three speakers this morning. You'll firstly hear from Bruno Herbots of Herbots Solicitors, then Jamie Ritchie from LK Shields, then Bill Bordill from Decipher. After Bill is finished speaking, he'll pass on to my colleague Paul Sheridan, who'll host a question and answer session. Paul Gibbons from Decipher will also join that panel. Should you wish to ask a question, please use the question and answer function on the bottom of your screen, which will be monitored throughout. Thank you. I'll hand over to you now, Bruno.
Thank you very much, Sean. Thank you very much, ladies and gentlemen. In 2013, the Construction Contract Act introduced adjudication in Ireland. Adjudication is an alternative dispute resolution mechanism. It is alternative because it is alternative. Instead of going with a dispute to court, you go to an adjudicator. Section 6 of the Act is very clear, and it specifies that a party to a construction contract has a right, a statutory right, to refer at any time, and I'm sure we'll come back to that, for adjudication any payment dispute. It has to be a payment dispute, not like in the UK where any dispute can go, but we can have a discussion what dispute is not related to payment. 2013, when the Act came about, I came on record and I compared this Act, which, as Sean said, was not a perfect Act and required input from the CIF and others. I compared it to Cleopatra. So was adjudication to the construction world what Cleopatra was to Rome, i.e. a beautiful illusion. I'm now asked 8 years later, when the CIF has also input into this, where we are with adjudication. Am I still thinking it's Cleopatra? Whether I should advise you to go to conciliation, mediation, arbitration, or DAB or DRBs, or, ladies and gentlemen, are you better off to go to court, where we have, after all, the administration of justice done by excellent judges? That is a question. Jamie will discuss with you case law regarding enforcement and what we have under the new court practice directions HC 105. Bill will then discuss with you key elements that you have to have and how technology can assist us with that. And then Paul will ask or divert to all the speakers the questions. But first, is it a Cleopatra? In the sense that adjudication is supposed to be very fast, cheap, and it takes all the lawyers out of the equation. Well, ladies and gentlemen, it certainly is fast. In fact, too fast, very, very fast. And if you're not ready, you will be in trouble. Cheap depends, because when it goes fast, your advisors have to help you and they have to drop everything to do it. And it is time consuming, therefore expensive. And I doubt very much you can do all of this without the input of a lawyer who will guide you through the process. So The one thing you will notice, though, is that where I was totally against adjudication, I have come to more and more like adjudication. And I explain that in this next 10 minutes. The process of adjudication does not start with the notice to refer. It does not start with the payment claim notice that is issued where you ask for payment. It actually starts when you commence with your construction work, when you commence with the services. That commencement date is very important and very often forgotten about. But that commencement date triggers off a period of 30 days, thereafter a further 30 days, thereafter a further 30 days. And what the Act tells you is that if you submit your payment claim date within a period of whichever date it is you are in the 30 days of the month, then 5 days thereafter, then you are protected by the Act. So that commencement date is very important. And if, like me, you don't like calculating, you can go on my website and I have a free CCA calculator, which will tell you where, from the commencement date, your payment claim date is, and thereafter you have 5 days to issue your payment claim notice, okay? If you do that, the payment claim notice must specify the amount you want to be paid for, the period that you're covering, the subject of your claim, and the calculations. What the Act tells you is if you have done that and you do that within this 5 days window opportunity, then the other side has 21 days to either agree to pay or disagree or a proportion what they are willing to pay or not to pay. We're not like in the UK, and I have to stress this because people kind of Google up adjudication and believe everything they hear in the UK. Ireland has its own Act, and in the Act it says that yes, you have to reply when you get a payment claim notice within 21 days, you have to reply, but it is not so that if you haven't replied, that therefore you have agreed and that sum has to be paid, which led to the smash and grab practice we had in the UK, not in Ireland. However, it is my view that if you haven't replied within the 21 days, that you could say that the dispute has now crystallized because you are under the protection of the Act, okay? Adjudication is binding, but it is binding until a different decision is reached by the arbitrator or the court. So you can go to arbitration or the court, but in the meantime, you have to pay. That is good for the construction industry because cash flow comes in. So binding, but that's the difference that you have with the other ADR rules. In arbitration, it is binding, but there is no appeal. Now, that's not appealing when you go to arbitration because that's it, that's the end. Mediation, we have the Mediation Act 2017, an excellent act. The Mediation Act will say that the mediator who will try to bring the parties together, see if they can find a solution. I call it the grandpa or the grandma approach by experienced people that will try to bring you together. It's not binding. We then have conciliation. Conciliation is a recommendation, but unless you reject it within a specified period of time, very often 10 days, it becomes binding. So you need to be careful. Then we have this DAB and DRB, which are dispute boards. Now they exist already for a long time. The FIDIC really brought the attention to it, the standard form of FIDIC. 1995, we had the orange FIDIC, introduced it. 1999, it is in there. The DAB is effectively a dispute board, more often for the very big projects where you have someone, an adjudicator appointed from the very beginning, and he or she will follow through the construction project, can be asked questions or can make decisions. When it's a DAB, it's adjudication, the decision will be binding, unless later on overruled by arbitration or by court. The DRB is a recommendation, so it's more akin to mediation. Do I like mediation? Yes, I do. I think mediation is the way forward if there is no, because there is no animosity amongst the parties. You can listen to someone that knows the industry, but mediation or conciliation does not work if the parties are not willing to concede, are not willing to discuss and understand what went wrong. So if you go the procedural route, then there is no point in going to mediation. Conciliation goes straight to adjudication. Adjudication, fast, very fast, but rough justice. You don't go to adjudication to get an absolute fantastic justice where all the points can be heard and all the points can be discussed. It's very fast. The beauty for the industry is that a decision could be made. Maybe not the perfect decision, very often not the perfect decision, but at least a decision is made. If you're not happy, you can then bring it to court or arbitration, but in the meantime, you should pay, okay? Contracting, sorry, the parties have to be ready. It's expensive, but what is expensive? Give you an idea. An adjudication would cost you in between 10,000, 15,000 euro. The person that loses will probably have to pay the adjudicator's fees. Your own legal fees, both parties pay their own legal fees. But if you go with a legal person, your legal fees will be in and around the 10 and the 20,000. So if you have a dispute under 30,000, question is whether adjudication is the way to go, or you might dabble around with it. But keep that in mind, it's not dirt cheap, okay? You must be ready. People say, I know that. But when the payment claim notice comes in, that's an immediate flag that there is a possibility that this might be referred to adjudication if you don't pay within the provided period, 30 days. So if you don't, you do not have the time, and I've seen that a few times now where I acted for a bank or I acted for a big client, and they want to put you on the suppliers' platforms, which is an absolute pain. It takes ages before you get in it. That's not working with adjudication. Now, again, the beauty of adjudication is that it is fine. We have a new panel, and I'm delighted to see that at long last, we now have also excellent female adjudicators on that panel, very good adjudicators. So, ladies and gentlemen, do I think it is an illusion? Well, it is an illusion. You won't get absolute justice. Yes, you will get rough justice, but at least a decision will be made, okay? So I have come to more liking adjudicator decisions, but it's not perfect. But I do need to tell people you need to be ready. Now, how all that is going to work and all the questions afterwards, I'm there for you. I would now like to pass on to Jamie, who will deal with the more complex issue of enforcement. Now, Jamie Ritchie, I leave that up to you.
Thanks very much, Bruno. Firstly, thanks to the CIF for chairing today, and to Decipher for hosting. We just heard an excellent overview from Bruno in relation to the adjudication process and the differences with other forms of dispute resolution within the construction industry. Clearly, conciliation still remains the foremost ADR dispute process in Ireland, but I think with time that's ultimately going to change. Since the introduction of the Construction Contracts Act in 2013, and since it came into effect in July 2016, there has been a degree of reticence in relation to embracing adjudication. We are somewhat of a small market, and a great premium is placed on repeat business, which is one of the reasons why many commentators would give for adjudication not quite catching on in Ireland. In terms of conciliation, there's a lot to consider in terms of the tremendous success rate in terms of settlements, which have followed recommendations. That said, in my own view, I think that adjudication will ultimately overtake conciliation, and I think that the recent judgments reached by the Irish courts will go quite some way towards supporting this assumption, which is what I'm going to talk about today. In the past 12 to 13 months, there have been several new cases within the High Court dealing with adjudication, some as JRs, others as enforcement proceedings, and dealing with cross claims. Given the historic reticence towards adjudication and the preference for conciliation in Ireland, there has been somewhat of a paucity of judicial utterances over the last few years. So it's welcome to see now that the judiciary is having the chance and the long-awaited opportunity to assess the intricacies of the CCA. So without further ado, let's move on to the very first case. The first case is O'Donovan and others, and Benai and others, and this is a case that was heard in December 2020 of this year. It involved an adjudication whereby OCS had claimed a sum of around 1 million in relation to an electrical works contract at Páirc Uí Chaoimh. OCS sought to adjudicate against Cork County Committee of the GAA, who was the employer under the electrical works contract. An adjudicator was appointed by the CCA panel chairperson, and Cork GAA sought to challenge this appointment on the basis that there was the original contract was formed under a letter of intent, which was dated the 10th of June 2016, which predated the coming into effect of the Act in July 2016. So their argument was that there wasn't actually a statutory right to adjudication on the part of OCS. So all fun and games. It's actually a reasonably tricky scenario to unpack, and there's a lot of legal theories that are put forward, but generally speaking, the court observed that the LOI had reasonably sufficient information to govern the relationships between the parties, and also had contractual obligations as a result. The LOI was argued to have superseded or been superseded by a main contract, which was entered into nearly a year later, around May 2017. Importantly, this contract had a clause which effectively stated that it would have retrospective effect. So another issue that then arose was that 90% of the works had been carried out under that original, under that original letter of intent. And the majority, if not all of the payment dispute was subject to that letter of intent. So a question arose over whether the main contract could have retrospective effect. Anyways, putting aside all of that, in December 2020, the court decided after the original stay had been granted that it would be in the best interests of justice to allow the stay to continue. And they applied the court Okanade test, which looked at, amongst other things, where the greatest risk of injustice would lie, and also in particular took into account the fact that there had been significant delay in relation to OCS adjudicating. The dispute had been going on for a number of years, and I think that the court took quite a dim view of that delay. Counsel persuasively argued that the court's approach in this instance would allow future parties to effectively short circuit the adjudication process by challenging jurisdiction and then going on to JR, the adjudication, which would undermine the Act. Counsel also observed that it would deprive OCS of their statutory right to obtain a decision within the designated timeline. So critically, the court held that the parties could extend dates out on adjudication proceedings by agreement to whatever timeline suited them, and certainly long enough to allow for determination of the judicial review proceedings. Now, at the time, the JR proceedings were fixed for a date in February 2021, and essentially the court would examine, as I say, whether they would have a main contract would have retrospective effect. This was an important case. It was the first big analysis of the CCA. We had an earlier case last year in the Hines case in May 2020, which granted leave for a jurisdictional challenge and a stay, but the stay wasn't challenged in that case, so we didn't gather a huge amount of information from that. Ironically, the JR hearing in this particular case that was listed for the February hearing. That hearing has since been delayed. There was an appeal lodged on the 12th of January 2021, and I'm informed through sources that the Art 40 judge currently has other significant commitments. So we are actually still waiting with the final judgment in this particular judicial review proceedings. So it's going to be interesting to see how that pans out. So this neatly then moves me on to the next case, which, after 2 jurisdictional challenges brought before the courts in 2020, stays granted and a little bit of uncertainty over the future of the adjudication process. On the 26th of January 2021, we're suddenly given the judgment of Gravity Construction and Total Highway Maintenance. And this is exactly what people in favour of adjudication have been waiting for. It's effectively the first example of an enforcement of an adjudicator's decision in Ireland. Gravity were awarded 135k net of VAT. Total Highway had initially claimed that a stay should be put in place because they wanted to arbitrate. However, they subsequently updated this position, indicating their willingness to pay the award together with the adjudicator's costs without prejudice to their right to subsequently prosecute arbitration proceedings. The application was brought before the court, and broadly speaking, it was under Order 56B of the Rules of the Superior Court to have the adjudicator's award enforced. Because of the change in position by Total Highway Maintenance, the issue before the court was really straightforward. There was 2 issues. One was costs, and the other was whether, in circumstances, whether an undertaking had been given to pay the adjudicator's award within 2 weeks, whether an enforcement order was necessary. And counsel for Total Highway argued that an enforcement order would not be necessary because it would have lots of negative connotations and ultimately the award would be paid. Counsel for Gravity were, on the other hand, saying, well, our client's been waiting 6 months for payment, and the court should give effect to the legislative intent of the CCA. So the court adopted a pretty pragmatic approach, and they struck a balance. They said that the appropriate form of order was an unless order. So this effectively gave the party leave to enforce the adjudicator's decision in the same manner as a High Court judgment, unless Total Highway paid the sum within 7 days of the judgment. So this decision is consistent with the principle established in the UK courts of pay. Now, I argue later, even if they wanted to go to a subsequent arbitration. But as I say, it's a big decision. It's something that we've all been waiting for, and really positive for the industry. The other big case, although it wasn't completely focused on adjudication itself, it had ramifications, and it teased out a lot of the issues relating to the construction contracts. It was Contra Gomez and Dragados BAM JV earlier this year. It involves a performance bond dispute where an injunction was sought by Contra Gomez in relation to a potential call on a performance bond, and it was an on-demand bond in relation to a subcontract for false work over the River Barrow in relation to the new Ross bypass, and the JV, Dragados and BAM were the main contractor. Contra Gomez procured their on-demand bond. There was a residual amount of around 135k still sitting in the bond in terms of liability. Prior to that, what had happened was that, in November 2019, there was an adjudication, quite substantial sums, around 1.157 million, with quite a substantial counterclaim of 1.482 million. Contra Gomez was only awarded 388k, but the JV's counterclaim only achieved 1k, roughly. So less than satisfactory result for the JV. However, on the same day and effectively immediately following the decision, the JV informed Contra Gomez that it considered the terms of the subcontract had been violated and requested payment of the residual amount under the bond. Contra Gomez were not impressed with this approach and effectively described it as a collateral attack on the adjudicator's decision, stating that it was reopening issues that had already been settled, and that they couldn't argue this under the performance bond. So there was also an issue raised in terms of what is known as Henderson and Henderson liability, which was an English Court of Chancery case from 1843, which effectively stated that a party may not raise any claim in subsequent litigation, which they ought to have raised earlier. Importantly, counsel for the JV sought to distinguish the claims made under the performance bond as being separate and materially different from those raised in the adjudication. Importantly, Contra Gomez's case turned on whether the JV was acting fraudulently, which clearly it wasn't. But a discussion did ensue to what extent it was necessary to bring forward cross claims in adjudication. And in this regard, the court observed the tight timelines provided for by the CCA and said, it would be extremely unrealistic to suggest that the CCA requires a party to put forward all of their counterclaims in an adjudication. The CCA does not stipulate that expressly, but also there's serious constitutional issues around that requirement. So that was shot down, and in terms of the wider dispute, because of that, Contra Gomez's attempt to secure an injunction ultimately failed on the basis that fraud could not be proven, because the payment on foot of the bond was autonomous of any adjudication. On-demand bonds are just that; they are irrevocable by nature, and often they don't even require evidence that the contract has been breached. So again, there's three big cases of the High Court in the last year that have shown support for the adjudication process and discussed the CCA in detail. Just coming to closing up, then it's worth mentioning the High Court practice note that has come in. The new practice direction will provide for enforcements on the first available Wednesday at 10:30 in the morning by Mr. Justice Simons. And this is a welcome development. I think it's no accident that we've had our first enforcement this year, and then all of a sudden we've got a practice direction dealing with enforceability and the process for that. So it's great to see it's a positive for the industry. Then finally, the CIF aims. Well, I think that the objectives of the CIF and adjudication, they're very much similar. It provides for an additional forum for resolving payment disputes and improving cash flow, which is only to the benefit of the CIF membership. Lord Denning quipped that cash flow is the lifeblood of the construction industry. So anything that encourages cash flow in the construction industry is a good thing for the CIF. I think when the process was introduced, there was certainly a feeling amongst main contractors that they were going to be targeted a little bit more in adjudication by their subcontractors, and that it would be used less as a tool to go after the employer. However, I think in reality what's happened is that presupposition has faded away a little bit, particularly now that we have fast enforceability. The CIF have issued a number of recommendations in relation to the 2013 Act, and I know that there's been regular meetings between key stakeholders. It includes the limiting of the scope of the Act. The payment dispute is too restrictive. There's obviously no definition of payment dispute under the Act, and professional and legal advisor costs being borne by individual parties is a significant consideration for any party proceeding to adjudication, particularly if one party has very deep pockets. So to conclude, I mean, we now arguably have our very own Makeup and Morrison, which was the first UK enforcement through the courts in 1999. It remains to be seen whether we'll get a full all bells and whistles case which deals with and sets out the key principles on adjudication. What we really need is a Carillion Construction and Devonport Royal Dockyard case, which authoritatively set out that to seek to challenge an adjudicator's decision on the grounds that he has exceeded his jurisdiction or breached the rules of natural justice is in the plainest of cases likely to be a substantial waste of time and expense. That is pretty much it for me. Happy to pass on to Bill Bordill at this stage. Thank you.
Oops. there we go. Okay, sorry about that, everybody. Let me see if I don't know. Jennifer, are you able to enlarge the screen to lose the pictures on the side? Anyway, thank you very much, Jamie, for the introduction. My role today is to introduce and discuss some of the more practical aspects of adjudication. Bruno mentioned that adjudication is rough justice, and that's a common terminology in the industry. Adjudicators prefer the phrase broad justice. Primarily, it gets this banner because there is a very quick process of 28 days, and the decision is based on the submissions made by the parties, which are obviously rushed in some instances if there's been a hijack, and obviously the outcome is reflective of the speed of the process and how the parties have made their submissions. If we could go to the next slide, please, Jennifer. Thank you. So, key aspects for preparing for any form of ADR, but particularly the speed of adjudication, is the timing, the availability of the people involved in the dispute, the records to support the submissions, and the focus and clarity of the substantiation with the submissions. So if we just start with the timing, the whole process starts with crystallizing the dispute, and Bruno mentioned that. So once a dispute has been crystallized, by the way, it's not been crystallized until the other party has had an opportunity to avoid or resolve the dispute. So once that process has occurred and the dispute is crystallized, there is a 7-day process to appoint the adjudicator. And in that process, the referring party must issue a notice of adjudication and then approach an adjudicator nominating body, then appoint an adjudicator and issue the referral notice. So that's quite a lot of things that have to happen within a 7-day period, and they have to happen in that sequence. So it's quite important for the person or the referring party to draft the referral notice before the notice of adjudication. The notice of adjudication will be issued first, but don't shoot yourself in the foot and give yourself only 5 or 6 days to draft the referral notice, because that document will take probably longer than that to draft. So once we've got through the 7-day period and we've got an adjudicator appointed, he will set a 28-day time period for resolving the dispute. And he has a contract with the parties to make a decision within that 28-day period. So he will not let it go beyond that unless the parties agree, and that's a separate matter. But the parties could agree to extend the period, but the adjudicator, without the agreement of their parties, will reach a decision within the 28 days. And his decision will be based on the submissions from the parties. So if the submissions aren't of good quality, then you will get broad justice. And that's just the inevitable consequence. So in the 28-day period, the adjudicator will allow both parties to make their submissions. So the period starts with the referral notice. So the referring party has made their submission, and he will generally invite the responding party to issue a response to the referral. Now, I've seen situations where fairly regularly the referring party will then issue a reply to the response, and then sometimes the responding party will then want to issue a rejoinder. And I've seen it go as far as a surrejoinder, a rebuttal, and then a surrebuttal. So all of these submissions all have to be put in front of the adjudicator within this 28-day period, and he has to consider all of them. So he's got quite a task on his hands. So the key words when we're thinking of timing are preparation and anticipation. So if you're the referring party, you're bringing the dispute before the adjudicator, you need to prepare well in advance. You've got all the time that you need to prepare your referral notice and then your notice of adjudication. But if you're going to be the responding party, you need to anticipate, because you're the one that's in trouble, really. you've got to anticipate that an adjudication may be coming and try and prepare for it, because you will be under the cosh of trying to respond to the submission made by the referring party, and trying to respond to that within the timescale. So if you think that there is a 28-day period to go through the referral, the response, the reply, rejoinder, and so on, the adjudicator is probably only going to allow you something like 7 to 10 days, maybe 14 days to produce your response. And then beyond that, probably only 2 or 3 days for each further submission. So it really is a fast pace, and it's a very strict timescale, because, as I said before, the adjudicator has a contract with the parties to reach a decision within 28 days. So looking at availability, strategically, start it when it suits you, or you may choose to start it when it least suits the other side. That's you to decide, but make sure that you don't have key staff on holiday. There's no planned operations for people. You can't plan for illness, but you can plan for planned operations. Do you need to rely upon previous employees? Key advisors, make sure they're not going on holiday. Don't start an adjudication when it really isn't going to suit your purpose. Looking at the records, well, records are the evidence. All tribunals make the decisions based on evidence. Adjudicators are no different from that. So it will be an evidence-based decision, and I'll talk about records in a bit more detail on the next slide. Think about witness statements. Witness statements are usually factual evidence or opinion evidence. You need whatever you can to convince or persuade the adjudicator that your position is the right position. And then focus and clarity. I've mentioned that because quite often we see, or I see, submissions which are very confusing, and a confusing position or a confused position is very difficult to buy into. So you may have all the merit on your side, but if you don't explain your position clearly, then you can confuse the situation unnecessarily. So I would suggest that you decipher complex issues, make it simple to make it convincing. Even if you have to drop some of the issues, focus on the substantive issues and don't clutter up your submission with irrelevant information. Quite often we see very, very large, complex documents that really do present a picture that's very difficult for an adjudicator to buy into. Your task when you're referring or you're submitting any submission is to persuade the adjudicator. If we could go to the next slide, please, Jennifer. Thank you. So I'm now looking at a claims submission, and this is broader than just a payment situation, and this is claims generally. Contractors' claims really need to focus on the four corners of cause, effect, entitlement, and substantiation. Think of C's, but think of them in a slightly different order. It's easier to look for the effect before you identify the cause, and the effect will be what's changed, what's happening on site that wasn't planned. That's easy to see. Once you've seen that, then look at what caused that, what was the event that caused that change to occur, and then look into the contract, because it's the contract that will give you your entitlement or your relief. Once you've satisfied 1, 2, and 3, look for substantiation, and this is the evidence. This is what's going to win the case for you. So this could be calculations, records, witness statements. You'll need a narrative to explain C's, and you'll need to lead the reader to the conclusion that you wish them to get to. Your narrative is really important. You need to set out what you plan to do on the project, what you did that was different, why you did it in a different way, and then conclude with the costs of doing it or the impacts of doing it in a different way, whether that's cost or time. If we could go to the next slide, please, Jennifer. Thank you. So records. This is the evidence. This is the who, what, where, why, when, and how. And the most important records are contemporaneous records. Those are records that are made at the time and shared with the other party at the time. It's very difficult for someone to refute that that happened or an event happened if they didn't refute it at the time. It's very difficult to refute it later. So records, contemporaneous records, are very convincing evidence. Examples of good records would be labour allocation sheet, site diaries, biometric entry systems, meeting minutes, photographs, sketches, notes, could be delay analysis, anything almost which records what actually happened. It doesn't have to be presentation standard material, rough notes, handwritten notes, anything that is a genuine record of what happened at the time is a good record, and particularly if it's contemporaneous and shared. Again, all decisions will be evidence-based, and good records will evidence what happened and support your claim. If we could go to the next slide, Jennifer, please. Thank you. So for technology, well, photographs, they've been around a long time. Videos, obviously, that's been around a long time. But consider time-lapse photography. So if you've got an external project, earthworks or a car park, if you could, on the top of a pole, have a camera that's taking a photograph every 30 seconds, 24 hours of the day, and we've seen that on projects, that produces fantastic records of what happened and when it happened all over the site. Because the problem is, quite often, you don't experience the effect of an event until sometime after it has happened. So you're not necessarily able to take the photographs at the time because you weren't aware that the event was having an impact or an adverse impact on your operations. Whereas time-lapse photography just records everything from the start of the project, and then you can go back through the photographs to see what actually happened. So time-lapse photography works really well. So I mentioned videos. Drone footage is one to consider. We've been in discussions with a company that can program drones to fly through buildings on a pre-programmed route every day at the same time, say 10 o'clock in the evening. And as long as all the doors in the building and there's no ladders or scaffoldings in the way, then the drone will just go the same route and take the same footage. And that will, it's basically creating a time-lapse video with a 24-hour gap between it. I've not seen it working yet, but I do believe it is available. And I've mentioned hard and soft copy for virtual hearings, because most hearings now are virtual at the moment. That may well change in the future, but I don't think it will go back to all hearings being face-to-face. And parties need to be prepared to still submit hard copy documents. Don't rely on just being able to submit Excel spreadsheets and Word documents. And the final thing there is for technology is data storage. Make sure everything is properly referenced and easily transferable to other parties. I quite often, when we're working as party representatives, receive huge files from parties where they've saved time in filtering it out and presenting it to us, but actually it's given us the problem of doing that, and that's far more expensive. It would be cheaper for the parties to have a proper data storage system properly referenced. And if you go to the last slide, please, Jennifer. And that's over from me. Thank you very much. And I'll hand over to Paul Sheridan.
Thanks very much, Bill. I can have a review here now. Can I just invite back all the speakers and also Paul Gibbons to join the panel, Jamie and Bruno as well, and put your cameras on. I suppose what the CF tries to do for its members is to help them to avoid disputes, but unfortunately it's inevitable that in some scenarios disputes do happen, and it is really, really great to have such, expertise sitting in front of us here today, giving their insights on what the members really need to do to prepare themselves to try and put themselves in a position to win in adjudication. Maybe what I might do is take a question from the delegates initially, and the first one we have here is there a time limit for appealing an adjudicator's decision? I'll just throw that open to anybody if they want to come in and take a go at it.
I'm happy to start with that one, and then if others want to input on it, that would be great. In terms of the UK, there was a recent case there a couple of years ago, Aspect Construction and Higgins Construction 2015, and it established that a party that's on the receiving end of a bad decision in adjudication, if they've had an award made against them, they have 6 years to challenge it. Now, there's nothing equivalent that has come out within the Irish court system as yet. There haven't been any judgments that deal with this point specifically, but from a party's representative perspective, I would, if I was on the receiving end, or I was advising a party that was on the receiving end of a bad adjudication decision, I would be wanting to get something out in writing on record as soon as possible after the adjudicator's decision that the decision was being challenged. And it doesn't have to be too specific. It can set out in very broad terms what the issues are, but that would be my approach. I don't know about others.
I would totally agree with that. The main problem is that if the bad adjudication decision is made, the money will more than likely have to be paid out. There was a bit of a lapse there for a while because we didn't have the directions of the court that we can go to the court for the next available Wednesday. Before that, it was kind of a bit of a uncertain territory. But the main thing is you'd like to go straight to, you pay the money, you go straight, and then you might even try to make sure that that money is blocked and cannot disappear in the nature. So I wouldn't wait 6 years if the decision is bad, simply because you have paid the money. So follow it.
Thanks for that. Bruno, can I maybe just go back to some of the things that you were referring to? And you know, I suppose one of the questions here is if an adjudicator finds in favor of a contractor, what are the key steps they must do to get paid?
So if the contractor has a decision from an adjudicator that is in its favor, so at that moment, effectively, in principle, that decision is binding. So but it happens, or it happened, and I think it's going to be less and less of that, that the other side doesn't comply with it and tries to object and tries to say, let this matter go to court. It's like any other decisions. You have a decision from the adjudicator. If the other side doesn't pay, then you have to bring it to court and get an enforcement notice that decision can be enforced as such. In the past, this could take a long time, but now we have, and that's what Jamie was explaining, which is very good. We now have the opportunity to go to the court rather rapidly through this new practice notice 105, where we can go quicker to the court and get a decision. And we have seen already that the court will follow all these kind of idea of natural justice. All of that we had heard in the UK is not going to wash here. I know Paul talked about broad justice. I stick to my rough justice. The court is going to say the act is there. It's in order to make sure that the money flows very quickly. So if I was to advise a client that has a negative, a bad decision, I wouldn't try not to pay. I would pay, but again, if it's not paid, you need to go to court to have it enforced.
Can I maybe just throw one more at yourself, Bruno? And this one is in connection to the right to suspension within the Act. I mean, you could explain the threat of suspension and how it can be used and not used in the event
Yeah,
of a dispute?
It's actually, it's very funny. One of the things we have to realize is that there's two legal systems in this world, and one is, you know, the English stroke common law system, which is the Irish system, and then you have the civil law system, which is really based on Roman law. One thing that the Romans already had for a long time, which is what they call the exceptio non ad impleti contractus, which means if you do not carry out your obligations under the contract, I can stop my obligations. We don't have that in Ireland, but the Act provides that if you are not paid, and that's one part of the Act that I really like, if you are not paid as a contractor, you can suspend the works. You can suspend the works, but to do that, you have to, obviously, a payment has to be due. You can't just, you have to say, well, this money was supposed to be paid. And secondly, you have to give notice on the other side. You cannot just simply stop working. But what you do is you write a notice and you say, I give you 7 days warning, but after that, I will stop working or I will stop providing services. The Act is very clear, you can do so. You have to stop when the payment comes. It's quite evident. But what you can't do is to issue, so to refer the matter to adjudication and then stop. That doesn't work. So you have, if the intention, and it's an absolute strength that contractors have, if there is a payment due, and if you notify them in advance, and if you don't want to go to adjudication or any other dispute resolution mechanism, stop working. It's a very efficient methodology, but you have to be careful. The Act does provide that at the end, if it transpired that you did that without merit, then you could be exposed, but it will have to be demonstrated that you did it without any merit whatsoever.
Interesting. Maybe Jamie, if I could come to yourself, and this might be a complex one, but it is something that we do get queries from members on. And you know, Bruno had mentioned conciliation and mediation as other forms of dispute resolution, but can a contractor go to adjudication while there is still an ongoing conciliation on the same dispute? And I suppose I asked this specifically in the context of maybe a public works contract, and just what happens in that scenario. Yeah,
it's a really interesting one. This question actually came up in a talk with SCL about a month ago, and it got a lot of interest. Broadly speaking, under the public works contract, under clause 13, basically the whole whether it's the dispute management process or whether it's a conciliation process, if you adjudicate, the conciliation effectively stands adjourned. That is the way it's set up under the contract. So to a certain extent, adjudication can short circuit a lot of the complicated technical multi-tier processes within the public works contract. And there's a reason for that. It's because the Act itself states that you can adjudicate at any time. So it cuts across those provisions. And I think a lot of people forget that. Now, I'm sure Bruno will back me up on this, but when you're going through, when you have a complicated multi-tier process, whether it's in an amended version of the RIAI contract, or whether it's in the PwC or in the private sector contract produced by the CIF, it's important to always remember to follow the procedures to the extent that you can. I think that it bodes well for a party if they are going to adjudicate that they've gone through the various stages. So if there's a phase of negotiation or interaction that you go through, you do that first. But ultimately speaking, you don't have to. You can just adjudicate at any time, and that means that the conciliation will adjourn.
And say in the event that you do go to the contractor goes to adjudication, it's not happy with the decision. Does the procedures for dispute resolution within the contract, can you go back into that process again? Or is it a case of deciding, look, not happy with it, the Act provides that I can either go to, I think it's arbitration or the courts, is it? I mean, it gets a bit tricky there. Can you give us a sense of what that, maybe Bruno, if you want to come in as well, and
Yeah,
I'd be interested to hear.
I'll say take my view of it, and then Sir Bruno can give me his. I think that you know, when you're going into the world of you know, when you've got adjudicating on the same issue, that's where you have the problem. My own view is that the adjudicator's decision is temporarily binding, and that's pretty clear until it's enforced, or it goes to arbitration. So that's my take on it. If you were going back into the dispute management process, it would need to be a materially different issue.
Yeah, and I would agree. But the question, I think if you start a conciliation or mediation, the idea is that you try to get what I have called, and very respectfully called, the grandpa and grandma specialist that will listen to the boys fighting and say, this is my opinion. But that mindset, if you then suddenly go to adjudication, and you can, then it's difficult to see how you can go back to the conciliator and you go back to the mediator and say, well, let's continue with this discussion. In the meantime, we pay out and we continue. I think at that stage, the conciliation and mediation is over. You have to pay because that's binding, and you go straight to the next step on the dispute resolution mechanism in the contract, which is either arbitration or court. And you go straight to that. If you want to, that is.
Thank you, Jamie. Thank you, Bruno. I might move on to some of the more practical aspects that Bill was referring to in trying to manage the actual dispute itself and provide records. Bill, you mentioned some clear, simple submissions work best. I mean, what have you seen in your experiences as an adjudicator?
That's a good question. I've seen the good, the bad, and the ugly. I've seen documents that are way too long. I was appointed on a fixed price adjudicator, so I committed to a very low fee. And then the referring party submitted a 200-page submission, and the responding party responded with a 300-page submission, and it carried on. When they're too long, the submissions tend to repeat what they've said previously, and sometimes they contradict each other. So I would aim on the side of brevity, keep the argument simple, make it very clear, make it easy to read, avoid contradictions. I've had a situation where a notice of adjudication was issued on a project in Reading, and then the referral came in on a project in Slough. So it was clearly a different dispute because it was a different town. So, you know, sometimes parties, and that was from the referring party, they rush into this process. And that was why I was overstressing before, that you really need to take time and don't adjudicate till it suits you, but get your ducks in a row first and do your referral first and then the notice of adjudication. What I tend to see from party submissions where there's been no legal representation is they're full of emotive language because they're passionate about their dispute. And that really doesn't help resolve the dispute. Whereas if there is a more measured approach from usually with legal representation, it tends to be a fact-based, succinct submission. And that's much easier for an adjudicator to deal with.
Thanks very much, Bill. Paul, I suppose carrying on the theme of what Bill is trying to say, you really got to be very clear on how you're managing your records and so forth, and measuring the progress on your side. I mean, if you've got quite a complex project, you know, you obviously get complex planning and programs and so forth. I mean, could you give us a bit of advice to those who are planning in the management of such complex programs and how they can collate their records and be ready, as the guys have said, that, you know, when that payment claim goes in, be prepared to submit if you have to?
Yeah, of course. Thanks, Paul. It's great to be involved with this event. So thank you for hosting it at CIF. It's been really good. As Decipher, we get involved with complex delay analysis and quantum issues. But with regards to the delay side, particularly around those delay events that are taken and referenced in adjudication referrals, we would always suggest that the parties try and understand what the contract is saying around the method of analysis to be adopted in the event of recording delays on a project. So we've got the SCL protocol that references 6 methods of delay analysis, but we've seen it on a number of occasions whereby the contractor has opted to choose one method of analysis, submitted that to the engineer, and the engineer has said, I didn't want it that way to be submitted. I prefer the TI methodology or the impacted as planned. And that can create quite a bit of debate and angst around the principle to be applied. So I would always say that have a look what your contract says. If the contract is silent around the method of analysis to be applied, try and reach agreement with the engineer or architect around, in the event of delays, how you're going to record the method of analysis. And then once you've got that principle agreed, make sure you've got the records in place and build reference records there that are to be relied upon. But don't fabricate those records. And what I mean by that is that you need to have good, accurate progress reports. And when you're using those good, accurate progress reports and you're placing reliance on those in the presentation of an as-built program, for example, make sure they reflect what the programs were saying at the time as well. So we've had a situation more recently where the contractor has been undertaking a TIA update on his program, and the contract, we're looking back here and doing an as-built process, and the as-built records do not correlate with the TIA updates that were being applied at the time. And so there's a complete conflict. And so you then go back to, where's the credibility? What records is the contractor placing reliance on? I would also suggest for those that are updating progress reports or progress programs, don't use the jagged line approach. I see this assessment as being subjective. Critical path activities are not identified. And in reality, I've seen that most projects are further behind than reported. I would always suggest that the project team use a straight line update, the critical path is identified, and these records and they record actual delay on the critical path. So I think you need to be very mindful about how you're going to be allocating the delays, what methodology you're going to be approaching it from, and how do you go about presenting your most credible claim to the other party to consider.
Can I agree entirely with that? Because this is a quite complex one, because we're now talking extension of time. We're talking the cost associated with the extension of time, because it's a payment claim notice we're dealing with after all. Your payment claim notice should be very clear what you claim and why you're claiming it and how you're claiming. So the calculation has to be in there. What is extremely difficult is if you are at the other side and you do not understand why the subcontractor or the main contractor is claiming delay costs, on what basis he is claiming delay costs. Extremely frustrating. But again, don't forget, once the notice is there, you don't have much time. So if you want to bring in an expert to help you out, a programmer, someone that can analyze whether what is submitted is just where the links are not linked together or it doesn't work, or more importantly, there is no baseline program, there's nothing, it's totally fabricated. It takes time. And I agree with Paul, no emotional speak, measured approach, fine. But before you as a lawyer, and you really need a lawyer to be able to put that forward, you need to understand what happens. And that's the problem. So once the payment claim notice comes in, once the person is claiming money and you see that, that's the time you should activate, not once you get the notice to refer. It's nearly too late. Can I ask a question? I'd be interested in the panel's view on that, because I've done quite a lot of adjudications and there's kind of a different view on this. Once we submit our records, as Paul referred to. Obviously, we don't have much time to do it. So we have our submission, and then we have the records, and the records could well be 1,000 pages, etc. I've recently put that in, submitted it in, and 2 pages were upside down. So the numbering went through, but the 2 pages were upside down. And I got an adjudicator that kind of asked me to redo the whole thing. Now, I thought that was excessive in the sense that you're working against a clock, and if 2 pages are printed in the upside down, just read it the other way around. It shouldn't be an issue. So I'd be interested in the view of the panel speakers, what they think. Should we be as strict? I don't even think the court would be that strict, but it happened to me, and it's just that I'd be interested to know what the panel's view is on that.
I think it's easy to agree with you there, Bruno. I think that is a bit excessive, but it's difficult to understand what problem that might have caused for an adjudicator. I can't see that it would cause a problem if there's only 2 pages. It's fairly easy to understand what's gone wrong there and what have you. I don't think 100 or 1,000 pages of evidence is a problem. I think if the narrative explaining the dispute is 100 or 1,000 pages, I think that's an issue. And I've heard many eminent barristers say that any claim narrative should be contained within 30 pages. Even the most complex dispute should be contained within 30 pages. If it's beyond that, then it's just too long. But obviously, the more evidence you can have, the exhibits and the appendices supporting that 30-page document, they can be as big as they need to be. And that's more compelling, it's more persuasive. And what you're trying to do is put a simple position in front of an adjudicator with persuasive evidence. So the more evidence you've got, I guess, the more persuasive it is, so long as it's not contradictory.
I would just add to that, the only thing that you've got to be careful of when you are submitting papers, and I think this is probably something which contractors who might do it themselves in the lower value claims, is just in the UK courts in particular, they've taken quite a negative view towards new information being put in the adjudication after the referral notice has been submitted. So you need to be really careful that you get all of the evidence in there at the beginning in the referral notice, and then your further documents that you submit, whatever it be, rejoinder, sur rejoinder, that information, reply to response, that information references the evidence. It doesn't include some new document or piece of evidence, because the adjudicator is likely not to pay attention to that new piece of evidence.
Yeah.
And I think just to add some further to that, Jamie, I think you've got to be careful as well with the submissions that you're relying upon in terms of Excel documents. So we, when we're producing and working with referrals, we will provide the appendices predominantly in a PDF and sometimes in Excel to allow the adjudicator to work through the calculations. But I've seen it in the past where referring parties have issued a PDF of an Excel document, a sheet within an Excel document, and then the adjudicator has asked to see the Excel document as a source document, and attached to that are all the other tabs that they didn't want the party to see. And that perhaps doesn't help the adjudication process when there's information that's been shared that perhaps shouldn't have been shared. So I think it's just understanding what information you're placing reliance on and how you are putting that across. And we as a business, we have lots of spreadsheets looking at commercial aspects, prolongation costs, disruption costs, and we will specifically just cut those documents out and give those as part of the referral itself. But then behind all that, there'll be all of our other calculations, assumptions, assessments, things that are confidential to our client that we don't want them to see, perhaps. So it's just these are the tricks of the trade. Just got to be mindful of.
Look, we're nearly 10 minutes over our allotted time, but at the same time, it's really important to allow this discussion and for the delegates to hear it. I know there's a couple extra questions starting to come in right at the end here. We will try and capture them, and we'll take them offline. and see whether we can come back with some kind of an answer to the delegates who attended. I want to thank everybody here today, Paul, Jamie, Bruno, Bill, and Sean, my colleague, and Jennifer, for doing a lot of the organisation in the background, and again Stuart, who's not here with us today, but I know he's in the crowd somewhere, for enabling this to happen today. So thank you all for your insights and your expertise and sharing that with us. It certainly seems that, you know, knowing your contract is really important. It's knowing when it starts for the day, and it's managing your evidence and what is actually happening on your project, and continually monitoring that and keeping records so that you can identify when, you know, potential claims are about to arise. And this condition precedent to most contracts now is really forcing you to do that, so that you have all the evidence in place if you do need to go to adjudication, rather than having to scramble and most likely undermining your own ability to win your dispute. So look, I want to thank everybody, and certainly in terms of delegates here today, this has been recorded. It will be put up on the CIF website, so you can access it and stop it. And maybe on one of those slow days on the site, which are very, very few, you might decide to do some CPD and review what's going on in the dispute world. So look, thank you very much. I might just invite my colleague Sean if he wants to say any closing words, and other than that, we wish you the very best of luck, and thanks again to everybody.
No, I think that was great, Paul. Thanks very much for closing off, and thanks, guys, for your time. Sage words of advice, Bill and Paul in particular. I think with regard to getting your data right and not overloading it, and take the emotion out of it and get the facts on the page. Thanks very much.
Thank you very much for having us. It's been very enjoyable. Thank you indeed.